SJC-13544, Commonwealth versus a juvenile.
Okay, Attorney Schneiderman.
Good morning, Your Honors. Backwards. May it please the Court, I am Joseph Schneiderman. I represent the youth. With me is Andrew Demota, his trial counsel in the Lawrence District Court. Your Honors, since common law, courts do not punish people whose conduct stems from mental illness. The judge's decision here to refuse to recognize criminal responsibility as a complete defense to probation violations in the face of an uncontroverted record that the youth was suffering from mental illness when he had the gun creates multiple untenable results. First, lack of lack of criminal responsibility constitutes a complete defense.
Mr. Schneiderman, you're a little loud.
I apologize. Thank you, Your Honor.
How do you deal with Eldred?
Your Honor, the record in Eldred was underdeveloped as compared to this case. Here we have a pure documentary paper trail that the Commonwealth, the probation opted not to controvert. Eldred came up on a reported question. The question of whether or not addiction was itself a mental illness that qualified was not as developed. Here, this court has recognized that schizophrenia is a mental illness that triggers a CR analysis. And in any event, we have an expert consensus that my client was suffering from mental illness, and we have an express conclusion by Dr. Bermigian at record 99 and 100 that at the time, my client could not appreciate the wrongfulness of carrying the gun.
I take your point about the factual differences in the separate analogous contexts, but I think the question really goes more towards the legal question and the standard to be applied. I think the court in Eldred reserved the question whether, in some cases, with a stronger factual basis, a person in Ms. Eldred's position could potentially, or at least the court reserved the possibility that they could potentially prove or defeat the element of willfulness on the basis of similar evidence. So could you address why the court should not take a similar approach here and hold that this all boils down to willfulness? And depending on the factual record, the person may or may not, the Commonwealth may or may not show willfulness.
Your Honor, I think that's precisely it, actually, that criminal responsibility would go to willfulness here. And courts that have not recognized the defense either don't engage in that analysis or overlook how willfulness is an underpinning of a lot of the due process.
Can I interrupt?
Of course.
My question was specifically, I wasn't entirely clear about the premises, not to import the affirmative defense of criminal responsibility, which is how you're framing your argument, but rather simply to consider willfulness. Is there a problem in your view with simply considering willfulness, as we have long understood it in the probation context, as opposed to considering the concept of the criminal responsibility defense as developed in the context of criminal prosecutions?
Forgive me, Your Honor. I'm not sure I follow. I understand Your Honor is asking about willfulness and the defense.
In some of the cases that are cited in your brief from other jurisdictions, the courts there have said, we are not going to import the entire affirmative defense of criminal responsibility into probation violation hearings. We are, however, going to allow courts to consider evidence regarding mental illness vis-a-vis the element of willfulness that is a necessary element for proving a probation violation. Do you have concerns about the court so holding here? I'm very interested to hear if you think that there are aspects of the affirmative defense of criminal responsibility as it is understood in the context of criminal prosecutions that are distinct from and important to be included in probation revocation hearings, in your view, probation violation hearings, in your view, as distinct from just focusing on willfulness?
I think actually there are implications for that, Your Honor. I thank Your Honor for clarifying. I think what is key about the criminal responsibility defense is it is always recognized that we do not punish, and there is something fundamentally unfair about punishing criminal defendants who just have no capacity to realize or cogitate that their conduct was wrong. That applies per force, I think, Your Honor, to the context of probation, where the purpose of probation is to get the probationer back on their feet. And if the probationer has done something that is not within their control or that is due to circumstances beyond their control, then not recognizing the defense becomes highly problematic, and it would, as Your Honor is suggesting, if I follow Your Honor's question, transcend willfulness. Justice Wendell, I think I saw you asking me something.
It's odd. Justice Gaziano, I think you have a question.
Whoever, I'm happy to answer anyone's question.
All right, if you could just take us one at a time. So on that point that you just made, we've distinguished in the willfulness about I'm a homeless person who's unable to charge the GPS because they have no outlet, right? That's the classic example of willfulness. But as you said, someone it's out of their control. What about the person who's really drunk and they wander into an exclusionary zone on a GPS? Does that person violate probation?
Your Honor, that would take us, if the person there tried to raise criminal responsibility, that would take us into the ambit of Dunphy, saying that voluntary intoxication, particularly where someone knows that their intoxication would adversely affect them.
You want us to import Dunphy and all that complexity into a violation of probation proceeding?
Yes, I do, Your Honor. I think that the aspects and the layers of CR are very important to import into probation violation proceedings.
What about someone who just has diminished capacity? Take the NGI out of it. You want us to go down that road as well?
Your Honor,
So it's like basically I'm on probation because for drunk driving and I'm too drunk to be on probation?
Certainly not, Your Honor. I don't think someone could be too drunk to be on
Okay, so then
probation.
I can't stop myself from getting into the car. I can't stop myself from going through exclusionary zones. I can't stop my compulsion for all sorts of bad behavior. That's the road you're taking us down, right?
Not quite, Your Honor. I think Your Honor's avenue, if I'm following Your Honor's road analogy correctly here, would be the probationer's violation there. The question may come up, but the Commonwealth or probation could rebut it by demonstrating that this was a voluntary choice to consume alcohol or to consume another intoxicant. That sort of nuance should go into it and would bear very much on willfulness. And the procedure, I think, more to Your Honor's question, the threshold burden to establish criminal responsibility is and always has been on the defendant. The defendant must establish that this is my organic, as this court recognized in Dunphy, my organic problem that makes me unable to appreciate the implications of what I'm doing.
It's the government's burden and normal criminal responsibility, aided sometimes with the presumption of sanity, although we've criticized that. But it's once it's raised, it's the government's burden to prove sanity, right?
That's exactly correct, Your Honor.
That would hold true in a violation of probation?
That's exactly right, Your Honor. This court should absolutely import.
Sounds like a trial to me, not a violation of probation proceeding.
Your Honor, BOPs may be, or I'm sorry, let me stop using abbreviations.
No, I get what you mean.
Okay. Probation violation proceedings may be more flexible, but flexibility cannot and should not import a dilution.
Most of the country says NGI is not available on a VOP. Some states say it is, and then some say it's a mitigating circumstance. I think that's just what Dewar was indicating as far as willfulness and or sentencing, right? And you want us to embrace the minority view.
Your Honor, I think that the prevailing view or the trend has been to recognize this as a defense, and I think to recognize it as a defense would comport with this court's evolving understanding, not just of the aims of probation, but of the reality of mental illness. So I think even though this is a new view, prior courts have not considered how the U.S. Supreme Court, the due process implications in probation violation proceedings. So I think this court wouldn't be wandering into uncharted waters.
Why isn't the fact that you consider it in the second stage, whether to violate the probation, whether to put them back, isn't that going to deal with the due process considerations and also essentially take care of all of this? if you're considering it in how you respond to the violation, isn't that as a practical matter going to address this problem? You know, and it does in this case. I mean, in this case, it's harder. The judge decides still to put him into the House of Correction, but that he didn't have to, and that may be wrong, that part of it. But isn't that where this should be fought out? Not in the whether he violated probation, but rather what's the appropriate response given that he was schizophrenic?
Your Honor, it's not enough to consider it just as a dispositional option.
Why not?
Because at the question at the first phase of a probation violation proceeding is a retrospective factual one of whether a violation has occurred, and criminal responsibility is a complete defense. If someone is not criminally responsible, no crime has occurred. By extension, no violation of probation would have occurred. To the extent the appeals court suggested otherwise in O'Garo, the appeals court was making a distinction without a difference based on dicta.
But what is the difference, Justice Kafker and Justice Dewar's point, between what you're arguing, which is there is no violation of probation, versus a consideration in terms of what to do given the violation, as a practical matter?
As a practical matter, Your Honor, if it were proven, there would be no violation of probation. If it is a violation, though, of probation, it would trigger a host of consequences for a probationer.
But,
So,
but there's a public safety consequence to it. I mean, this case, no one was harmed exactly, but your analysis would apply if he goes out and rapes somebody, right? So he's schizophrenic and he goes out and rapes somebody, but he still shouldn't be violated under your view, right? Because under your view, there's no second part of this analysis. He didn't violate probation, so he should still be out on probation.
Your Honor, he should still be out on probation, but judges are not powerless to do something. The judge could make a referral to the court clinic. If the probationer is truly a danger, then the court clinic could opt to invoke the procedures under Chapter 123 to seek civil commitment. So it would not be a get-out-of-jail-free card, for lack of a better word here. It would be the probationer, if shown to be a danger because of their mental illness, has to be taken down a separate road to be dealt with, rather than in the sort of box of a probation violation proceeding.
Would you remind me whether you're arguing that the defendant was schizophrenic and did not understand the wrongfulness of carrying a firearm? Is that the argument?
That's precisely it, Your Honor, that he was schizophrenic, his schizophrenia had a sudden onset, and that he did not appreciate the wrongfulness of carrying the firearm when he did it because he was operating under a delusion.
I thought he was carrying a firearm to protect himself, but it wasn't that he didn't know he wasn't supposed to have one.
Your Honor, he was carrying the firearm because of his delusion. Dr. Bermigian's report at record 93 to 100 details what he was enduring at the time. He believed that there were people out to get him and to harm his daughter, and he obtained the firearm. In retrospect, he realized he could not possess the firearm. But at the time, and that's Dr. Bermigian's conclusion, at record 99 to 100, that he could not appreciate wrongfully carrying it because he was operating under a delusion.
Just to be sure we're clear on this, I understand your answer to mean that if the criminal responsibility defense did exist, you'd be proceeding solely under the inability to appreciate wrongfulness of conduct, and you are conceding that on the record and with the evaluations that we have in this record, you are not proceeding under the inability to conform to the law.
That's correct, Your Honor, yes.
But isn't that the willfulness prong?
Yes, it is, Your Honor. The inability to appreciate
So then,
would be...
under the construct that Justice Dewar pointed out the first time, unless you have the second prong of the test, it's going to be willful, it's intentional.
That's correct, Your Honor.
That's why you don't want it, because you lose?
I beg your pardon?
That's bad for you, right? Because you want to go into either prong as opposed to the latter prong, right, of the McCool test.
On this record, Your Honor, it's the first prong because Dr. Bermigian's conclusion is that it fit the first prong. In future cases, it may very well go to both. I think, though, as Your Honor and I,
Willfulness is only really the second prong.
I'm not sure I follow that, Your Honor.
It's the volitional part of it.
Your Honor, to suggest that it just goes to volition, though, would be to eradicate any sort of consideration, though, of the circumstances and the probationer's.
No, I can't charge my GPS because I don't have an outlet, right? That's willfulness. It's the intentionality of the violation.
That's correct, Your Honor, but it still would not account for, if I follow Your Honor's question, it would not account for.
No, I guess what I'm just trying to say is that if we break it down and just focus on the willfulness part, it really bifurcates the NGI or the criminal responsibility test. And your position is we should look at criminal responsibility and say there's no crime at all, correct?
Yes, that is, Your Honor. I'm sorry. I did not mean to get into a dispute with you.
No, and then that's the same thing as saying there's self-defense, so there's no crime.
Exactly, Your Honor.
All right, I understand. You're
Attorney Schneiderman, I have one final question. Thank you, Chief, for the indulgence. This entire process that you're describing, we've said over and over that it's post-dispositional. You don't get all the same constitutional protections as you would pre-dispositional. But how does this fit in the Commonwealth's overall concern with the efficient resolution of probation? I'm from the community courts, and I'm very protective of the fact that the vast majority of people that come through those doors are going to get some measure of probation in the resolution of their cases. We all know the realities that people have undiagnosed or some underlying mental health conditions. How are we going to actually efficiently and effectively resolve probation violation matters if we go down the path that you're talking about? And I mean as a practical matter.
Your Honor, as a practical matter, this assessment, I think, would fit the standards of good cause, which is in the district court probation violation rules, the juvenile court probation violation rules, and it couldn't be something that was sort of left hanging in the ether. Defense counsel should be diligent, particularly where defense counsel bears the initial burden. So to the extent that there is a concern about timing, actually this goes to what I was trying to answer before, which is flexibility does not connote dilution here. Flexibility, if the issue is appropriately raised, then it would be something that would justify additional timing, and it should not function as a dilution, particularly where the alternative is untenable, which is potential punishment for status. Unless Your Honors have further questions, I thank you for your time.
Okay, thank you very much. Okay, Attorney Wakoni Zhang.
May it please the Court, Kristen Zhang for the Commonwealth. Based on this Court's precedent and the reasoned decisions of other jurisdictions, a probationer may not assert a criminal responsibility defense to a violation of probation. Rather, evidence of the probationer's mental state when they committed the violation is relevant to the disposition of the case.
Well, I'm going to start with what I left off with, because you say that, but there are these downstream really, really important and negative implications to probationers. So let me start with the first domino. So whenever you're in a violation session, the court has to make a determination that there was a willful violation of an order of probation, a condition of probation. So why wouldn't it make more sense for this to be the determination during the adjudicatory phase versus the sentencing phase? And I say that not as a matter of concept, because you know what the Commonwealth does when folks come back with requests for bail. They point to all the violations of the probation. They point to the fact that people didn't come back for things as reasons for why they're asking for higher monetary bail. So it's not just something conceptual about doing it during the dispositional phase versus doing it from the adjudicatory phase, because that's captured in the carry when the VOP hits.
And the Commonwealth concedes that. These do have very real implications, but at the same time, in these situations, it's a real red flag to the court that probation is not working anymore. If there was an affirmative violation, there was an affirmative act taken as a violation of probation, that is a huge flag to the court that maybe this
An
is,
affirmative willful act.
yes.
Right, but if it bears on the issue of willfulness, why shouldn't it be considered as part of the adjudicatory phase?
Well, I can address that head on. So I would say under Henry and Canadian, if I'm pronouncing that correctly, yes, this court has held that there must be a willful violation. However, both of those situations involved a administrative technical violation, and in both of those cases, the probationer did not do something, was unable to fulfill their conditions of probations by failure to do something. Failure to pay a fee that they couldn't afford to pay, failure to care or have this GPS machine charged because they didn't have a reliable outlet. In this case, we're dealing with probationers who took an affirmative act. And
But when we look at the self-defense cases, right?
yes,
We say, well, it's not a crime because you have the right to defend yourself. That person has committed no crime.
correct.
Last time I remember, when we instruct the jury on an NGI case, we say someone who is not criminally responsible has committed no crime. That's the jury instruction. So why don't we treat this similarly where the probationer, although they did do an act, and just like if someone tried to stab me and I shot them, I did an act. I've committed no crime. When I act in perfect self-defense, I commit no crime were I to be NGI.
Well, I would say, especially in the probation context, we're looking at what conduct is acceptable for a probationer, who's someone who doesn't have all the liberty interests as any other person walking around. So, sorry, I lost my train of thought. So I did cite some cases that.
No, I read the ALR.
Yes.
Basically, it sets out the three options we
Sure.
have.
Sure, it talks about the different, well, the Illinois case in particular that I cite in my brief talks about the difference between self-defense and a criminal responsibility defense. This is not behavior that as a society we accept. Self-defense is behavior that we as a society have accepted. You have not done anything wrong.
But why do we have an NGI defense if that's not something that society accepts?
Well, if you look at all the case law, it talks about fairness to the person. We don't want to subject this person to criminal sanctions because of this behavior, because they're under the effects of a mental disease or defect.
Right.
So it's really the fairness to the person of subjecting them to criminal sanctions, and that's not what we're talking about here. This person has already been convicted of a crime.
If I had someone on probation for armed robbery,
Yes.
and they violate probation with a new robbery or carrying a firearm, and they might have schizophrenia or be, truly NGI, I can sentence that person under your scheme to 20 years in prison.
You can,
right?
but we
Isn't that
give
kind
the
of-
judge.
Isn't that kind of a punishment for a crime?
Right.
That's the difference between the first and the second phase, I would say. The first phase is focused on, was there a violation here? It's a signal to the court if there was a violation that maybe this is not the correct disposition. That's why we give the judges so much discretion in the second stage of the proceedings, because I can conceive of a scenario where there was a violation, maybe the person is being treated, there was a violation, but maybe there's a mental.
So what do you tell the trial judges? We say, this is dispositional.
Yes.
You have to, well, if you find that they committed the crime, physically committed the crime, you can find them in violation of probation, and then on disposition, do what?
They have to consider evidence of mental state that's brought by the probationer. It has to be part of their consideration along with everything else that they consider during this stage.
Counsel, could you just remind me, in the record appendix, is the judicial order of probation in there?
I believe it is.
Do you know, as part of the original order of probation, whether this probationer was required to seek or maintain mental health treatment?
I don't believe it was, and that's why this case is actually really perfectly teed up for this court, because he wasn't facing any of these mental health issues when he was sentenced.
It brings that dovetails to my point. So to the extent that we're talking about during the adjudicatory phase, that the probation, the judge presiding over the VOP session looks at the judicial order of probation, and that at the time of the sentencing of the index criminal case, no one knew that the probationer was suffering from any underlying mental health conditions. But now you have this.
Yes.
So why does it make sense to say, I'm going to issue a violation of probation based on an underlying condition that no one knew about or thought about at the time we put you on probation? Now we know. So I'm going to input the VOP, but then on sentencing, I'm going to take into account that you're now suffering. How does that make sense? It's backwards, right? Because if there's a therapeutic response that's necessary, wouldn't that be, let's amend the conditions of probation? But are you saying that we can't do that without the finding of VOP?
No, absolutely not. There is case law saying if there is a material change in circumstances, you absolutely can. But I think going forward under the framework that my brother suggests, it would take away the judge's ability to revoke probation in the cases where that's maybe the appropriate disposition, which I would argue was in this case. This probationer, you posed a very serious public safety risk to the community.
But, sorry.
No, yeah, thank you.
So I'm confused, though, about the result here. Yes. So if he really was not guilty by reason, whatever the standard is, putting him in prison seems odd. I just feel like the judge may have done the first part of this analysis in revoking, meaning he just didn't buy it, and then he puts him in jail. Is that a problem? Because then you can't really confront the issue properly. Was that clear? I'm worried that it made no sense to put the person in the House of Corrections if he really was schizophrenic and it was an act that he couldn't control.
Sure, and if this was his first violation, and maybe the act that we're talking about here was not bringing a loaded firearm into a hospital, maybe that would be true. But under the facts here, given also his record, given also his prior violations of probation before he had any sort of mental health issues, the judge said over and over again that this particular person was well known to the court. She knew the family, she knew the situation. So it wasn't just the violation of probation that the judge was looking at here. So maybe if that was the only fact on the record that this kid really, this was the first time the onset of these symptoms.
And what does the judge do about the mental health issue? Does the judge do anything but violate? Is he sent for analysis? I mean, is there anything happens related to the schizophrenia and the mental health issue?
Again, it's so case by case. In this particular case,
in this case.
In this case, there was also a parallel criminal action happening, and he was actually committed under that action and got treatment that way.
Okay.
So by the time he was presenting in front of the court, he was actually treated with medication.
so
He was
he's
doing
under-
pretty well.
So he's committed under Section 123,
Yes.
parallel with this.
Right, right,
Okay, so
exactly,
that's-
yes.
Okay, so that handles that issue.
Yes. That's why it's so case by case, because it's just depending on how the probationer is
How does that
presenting.
implicate the public safety issue you were talking about?
So just the fact, the nature of the violation here, him going out and arming himself, and there
Oh,
is
but now
evidence.
he's committed, right? Was that before?
What's that? I'm sorry.
I thought you said he was committed in the separate proceeding.
He was committed after, yes.
But then you're saying that there's a public safety issue that allows the judge to reimpose a sentence.
Right, because what came out afterwards in some of these medical records was how easily he was able to arm himself, the fact that he had this gun in his home with the family there and they
But
didn't know about
he's
it.
committed, right?
He's been released.
Oh, he's been released?
He's been released. I'm
Okay.
sorry, I misunderstood the question. Yes,
Thank
he's
you.
since been released.
Okay, that was my concern.
Can I ask you a question? Sorry, this is just a technical question, but I didn't understand your briefs to be making an argument, and I want to make sure you're not making an argument that that the defendant here waived the argument on willfulness. We've been discussing what the judge did below vis-a-vis the adjudicatory phase, and as I read the transcript of the hearing, it appears that the adjudicatory phase was somewhat skipped with respect to these issues, that it was essentially argued with respect, these issues were argued with respect to the dispositional stage. Do you think that that's a fair characterization of the record? I didn't understand you to be, you've addressed,
Yes.
appropriately addressed all of the issues, which I appreciate, but do you think that I mean, going to my colleague's question about what the judge did here, do you think there was or was not a finding with respect to the adjudicatory phase on willfulness regarding this person's mental illness?
There was nothing in the record specific to willfulness. In some of those earlier transcripts, this issue was raised whether this defense can be brought up, and that was sort of taken care of, where she wouldn't even consider any of this evidence during that first adjudicatory phase. So in a sense, it was sort of covered under that. I sort of took the judge's actions to be doing both at the same time, to be honest.
So in other words, you read the record as sort of essentially the judge made clear to the defendant that the judge was not going to consider this evidence at the adjudicatory phase, and therefore it was not considered at that phase,
Correct.
and only as to disposition. Thank you.
Correct.
Could you, Justice Gaziano's question to Mr. Schneiderman, could you address Eldred? Just how do we interpret Eldred in this context?
Sure, it's difficult. It's a difficult. So that's another case where there was an affirmative act, right? Just like this one, there was the probationer took an affirmative act, and that was the only other case I could find where this court kind of was faced with these circumstances, and that's why it is so difficult. And I would say that this court in Henry and Canadian did not anticipate the willful requirement to apply to such an important condition of probation, which is to comply with the laws of the Commonwealth.
But Eldred didn't settle this one way or the other.
No, it did not. It did not. If there are no further questions, I'm happy to rest on my brief.